going to thank you all for coming, but you have to be here anyway. But I would like to thank the organizers for inviting me. This was quite a nice surprise, and I'm really honored to be here for the first time. I'm also going to just say, in all honesty, I am really, really, really ill today. I should not be here. I should be at home, wrapped up in a blanket, doing what I do best, which is watching disaster films about sharks. So if my voice goes, or if I just like fall over, just ignore me and go to the pub. So I want to thank you all sincerely for taking enough interest to come in here to talk about developing for privacy and user protection. This talk isn't the be-all and end-all, and it's certainly not legal advice, but what I hope it's going to do is kickstart a discussion process in your own mind, if not within your projects and your workplaces, about how you can become more proactive and conscientious about putting your users' protection and safety first and foremost in everything you do. What you're going to learn today is I'm going to give you an overview of the changing data protection and privacy landscape. And then we're going to go into the different cultural and legal views of privacy that exists within open source communities and our own projects and even our own workplaces. And then I'm going to give you a methodology I've been working on that will help you evaluate your work for best privacy practices outside what you may have done up to date, which is to think of it in terms of legal obligations. And what you're going to do with that knowledge is you're going to learn to respect privacy as a positive cultural value, not resent it as a negative legal obligation. You're going to learn how to integrate these best practices into your development workflow. You're going to think about reviewing some of your existing work for potential improvements. And you're going to be inspired to contribute to open source privacy. So let's have a little bit of a workshop on an overview of how the data protection privacy landscape is changing for all of us. All of you will have been aware from your own projects and workplaces that we've just had a complete overview of the privacy regime in Europe. We all spent a lot of time working towards the implementation deadline of GDPR, which was the 25th of May this year. I'm a core component maintainer of the WordPress core privacy team, which worked to get a couple of compliance tools shipped out to 31% of the websites on the open web. No pressure there. The GDPR replaced what we had before, which was the Data Protection Directive of 1995. It's always been really remarkable to me to think that everything we have ever done on the web was based on a privacy law from 95, which was floppy disks and dial-up internet. So GDPR maintained everything that was originally there in the Data Protection Directive. Very little of it was new. What GDPR did was expanded, modernized, clarified, and just brought things up to date with obviously how things have changed in 23 years. Now, GDPR deals with data at rest. That's our data collection, our usage, and our retention. What a lot of people don't realize, though, is that GDPR is only half of that double matrix. The other half of the European privacy regime is called the e-privacy directive. And every time I give this talk, I have to change what's after TBD because it keeps changing. It was supposed to go live on the 25th of May. It's not even out of draft yet. The latest they're saying is maybe spring, March-ish. Don't rely on that because it's probably going to change. And this replaces the e-privacy directive of 2002. This is a European law dealing with data in transit, not at rest. So things like cookies, telemetry, marketing consents and permissions, advertising beacons, that sort of thing. You know it, rightly or wrongly, as the cookie law, where I could do a whole talk on either of these, and I'm not going into that. But what you do need to know is that GDPR was sort of like the first half. We're going to have to do all of this again next year. I have done entire talks and white papers and briefings on GDPR. I don't ever want to take any GDPR work on it again because it took up 2 years of my life. And you're welcome to watch those talks on my website as a hobby. But very, very briefly, what you need to know is I found it useful in all my education to split GDPR into 3 areas. It deals with what you have in terms of awareness of what data you're taking in and retaining. Documenting what you do with it, why you do it, where you put it, who you share it with. Your privacy notices, so your public-facing communication to the people the data is about over what you're doing, why you're collecting it, what rights they have over it. And sort of a niche item, but if you're collecting or processing data about children, there are special rules on that. GDPR deals with how you engage with people in terms of their individual rights over their data, privacy by design and data protection by default, which is how you structure your projects, and we are going to speak with that. how you secure permission to use that data, which is either through consent or through a lawful basis to use it. And it also impacts how you work as projects, as businesses, in terms of subject access requests, which is how people invoke their rights over the data you hold about them. Data breaches, what you do to prevent them and prepare for them. Data protection officers, which are the actual named individuals for whom privacy is their job within your organizations if you meet certain criteria. And international, which is how you send data outside the European Union to countries that are outside the EU's privacy regime. And oh my God, am I going to be doing a lot of talks on this next year? Because we're about to be one of them. GDPR and European privacy law in general deals with what we call personal data. Under the European privacy regime, personal data is any information relating to an identified or an identifiable natural person. And this can be one piece of information or multiple data points combined in a record. There's also another category of personal data called sensitive personal data. And this is information about people's racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, health data, sex life or sexual orientation, or past or spent criminal convictions. And you can easily think of the reasons why this data is more important. The example I often use is, you may have seen that there was a thing that Grindr, which is the gay dating app, was leaking information about people's HIV status. So a key component of Grindr is location data. So you would actually be able to identify who in certain phases of HIV was physically near you. GDPR added some new definitions of personal data to the 2018 revamp. So personal data now includes genetic data. You've all seen these ads, to take a spit swab and send it into some genealogy site and they'll tell you who your people are. Biometric data, which is things like facial logins or fingerprint data, a fingerprint login on your phone. Location data. And online identifiers, and this is a category which impacts all of you, which is any sort of online identifier, a database entry, a customer number, anything that can be tied to a person's identity. So that is personal data. Now, a term you might have heard a lot is PII, personally identifiable information. What you need to be aware of is that's not personal data. PII is an Americanism. It's a specifically American term. I'm not going to read the whole list, but PII, the American definition, is specific things. The European definition is anything which could identify an individual. The American definition, it's got to be one of these things. It's something like your license plate number. It's any information about an individual maintained by an agency that could be used to distinguish or trace their identity, or any other information that is linked or linkable to an individual, such as medical, educational, financial, and employment information. What might be PII? There is a bit of room and leeway, but it's things like first or last name, gender or race, criminal record, cookies, but again, it's all contextual. And sometimes when you are doing something like, I think Google Analytics was something, it'll say something like, we adhere to all laws about personally identifiable information. And that should raise a red flag to you, because that means they're talking about data in the American context. You need to make sure they're talking about personal data, otherwise they're talking about something separate. So who is subject to the European privacy regime, GDPR and EPD? It pertains to all data which is collected, processed, and retained about persons within the European Union. It's not contingent on nationality. It's not contingent on citizenship. If you're an American in this conference here, your data that you're generating and producing here is protected. It doesn't matter that you're not a British citizen. It is extraterritorial, and this is where people tend to hit the roof. It applies to non-EU collection and processing. So if you're a Canadian business doing business with European customers, whether that's providing a paid service or even just collecting their data for a free app, their data has to be protected under the European privacy regime as if that person was there, as if the Canadian business was in Europe. And it pertains to all capturing and processing of personal data. There's no minimum size or turnover. A one-woman business, self-employed person has the same base requirements as the biggest corporation. And as I said, it applies to all situations, public sector, private sector, academia, startup, side project, or hobby. What the European law is it's called an omnibus law. You might want to call it an umbrella law. That means it applies to all situations, all sectors, all capturing, regardless. Now, for the longest time, for as long as we've all been online, this has sort of been a European issue. But we're going to talk a little transatlantically, because what's happening now is the United States is getting ready to do something they have never done before, at least not in the European context. They're getting ready to legislate privacy. There are any number of draft laws and ideas and concepts and proposals being floated. None are official, none are on the books yet. And every time I give this presentation, I have to add another box or two, because these are just some of them. I need to take a week and lock myself away in a room and look at all these in depth, because some of them are absolute rubbish. Some of them are very politically motivated. Some are little more than glorified ideas on the back of a pub napkin. But the one that has passed is CCPA, the California Consumer Privacy Act. And that is, I hate to use the term GDPR light, but for the ease of conversation, that's what it is. That is that any business over a certain size and turnover, which is collecting or processing data on Californians, has to protect their data in accordance with certain principles, which look an awful lot like GDPR. And that's going to be, along with the e-privacy directive, that's going to be one of the two big things you're going to have to work on in 2009, because any company that's collecting data about Californians now has to do certain privacy things. And this is a big for digital, that the United States is going to have some sort of privacy legislation in one form or another. But why does that matter? It's a big thing. And it matters because of the different cultural, historical, and legal views we've held about privacy across the Atlantic, which are very, very different. They're more different than you ever realized. One thing I realized in the 2 years I spent working on GDPR is I did it wrong. I did it all backwards. I assumed that everyone knew everything I'm going to talk about. I assumed we were all cognizant of that background, and they weren't. So now I'm doing things the other way around, and I'm talking to you about these different cultural, historical, and legal views before I can get you to talk about the code, how you actually implement these things into your code. Because this matters, because what are we all told all the time is that open source is made by the people who show up. But we all show up with very different cultural approaches to privacy. It matters because, for better or for worse, tech is dominated by companies in the US. And we're here serving them from Europe with that different cultural, legal, and historical approach to privacy. So let's talk about our different cultural approaches. In Europe, we hold that privacy is a fundamental human right. It's like the right to breathe air and drink water. We hold that data belongs to the subject. The data you're collecting about me is mine. We have an opt-in culture. That means you're not allowed to collect or process my data unless I give you opt-in consent to do it. We have a culture of constructive work when there is a privacy concern through data protection regulators. We have the ICO here in the UK, there's CNIL in France, there's DPC Ireland. Every European nation has a data protection regulator to police and enforce data protection law. So we work constructively through them. They're not traffic cops. They're not wandering the World Wide Web looking to issue tickets and collect fines. They work with you. And fines are a very rare last resort. Court action is almost unheard of unless you're Facebook and Cambridge Analytica, in which case it's actually tripped over into something like a crime. Also, we have a cultural tradition of trusting governments and fear businesses. That's not to say that we just roll over and let things be done to us. Let's not talk about Brexit, but we don't take the same approach that Americans do, and I will get to that. The American cultural approach to privacy is very, very, very different because Americans hold that free speech is a fundamental human right, not privacy. And in fact, there have been court cases where privacy has actually been ruled to be an impediment to the First Amendment right of freedom of speech, because someone invoking their right to control their data is interfering with someone's right to do what they want with it, because that's freedom of speech. Accordingly, the American approach holds that data belongs to the site or service owner. If you've collected data about me, it's yours. I don't really have rights over it, and I've got to beg you to give them to me. And accordingly, the United States has an opt-out culture. As I just said, the tradition is to collect and process the data about you without your consent, without even your knowledge. If you want to complain about that later on, that's your prerogative, but they don't ask. Because there's no privacy law in the United States, there's a culture of adversarial courtroom litigation. It's why you see, and we'll get to this in later slides, there's no data protection regulator, so there's no constructive party to work through. And there's no data protection regulator because there's nothing to regulate. And people fear governments and trust businesses. It's not to say companies are seen as benevolent, but a quote I read in some story about this was, the fear of government intervention is more off-putting for Americans than the abstract risk of privacy invasions. It's worth noting that these cultural differences were born from very different historical approaches. In Europe, our approach to privacy has been collective and social. We hold that human rights trump individual rights. I shouldn't have used that as a verb. We actually, we have a legacy of holocausts, genocides, and state totalitarianism. I mean, this year alone, I've spoken in Northern Ireland, I've spoken in the Netherlands, I've spoken in Germany, and I've spoken in Serbia. I mean, these are all countries which learned the hard way that you need to protect and respect people's privacy. So our approach is very much a form of atonement, that we have learned the hard way what happens when we don't protect people, don't protect users, and we've taken steps to do that. They don't have that experience in the United States, so they have a very different approach. Theirs is individual. They believe that individual rights are more important than individual human rights. I read a fascinating research paper the other day that actually traced this legacy, the two legacies that the American historical approach to privacy were born from. One was the East Coast Puritan legacy, the notion that private life should be public and your community should police you. And we're in Scotland, we actually know that as Calvinism. You know, this notion that not only should all your private business be public, but if you want to keep something private, you must be covering up some sort of sin. And that contrasts with the other thing, which is the American West Coast frontier legacy, like the idea that this country is yours and you can become whatever you want and you can do whatever you want and you don't have to ask for it because it's yours. So this notion of no consent and everything in public is in stark contrast to the European historical approach, which learned the hard way what happens when everything becomes public and your business becomes everyone else's. So these very divergent historical experiences led to very different cultural, legal approaches to privacy. In Europe, we regulate privacy through hard law, EPD, GDPR. And we have that one overarching law. We have data protection regulators. Privacy rights are not contingent on your citizenship or nationality. Privacy is its own set of law, and litigation is the last resort, if it even gets to that. Whereas the American legal approach to privacy is that privacy is governed, not regulated, through soft law, which basically means industry codes of conduct. Look how well that worked for Facebook. And because there's no overarching data protection law, there's a piecemeal approach across sectors and states. You've heard of HIPAA, which is health information. You've heard of COPPA, which is children's information. I've just told you about CCPA, which is California. But the exact same set of data may have no protections in another state. There's no data protection regulator because there's nothing to regulate. It is very much tied to citizenship or nationality, which is why you have Americans going apoplectic about GDPR. Because there's no privacy law, it's sort of seen as a subcategory of contract, tort, or even property law, which is why the current round of congressional hearings into whether the United States needs privacy law and what it's going to look like, it's called things like consumer privacy. There's no concept of privacy just being a given and a right. It has to be consumer privacy, which is it's only authenticated through a commercial transaction. And of course, litigation's the first resort. Sue first, ask questions later. So these differences shape our approach to compliance with privacy in our open source projects and our communities. And I'll give you a tale of what happens when these two come together. This is a pal of mine, Chris Wigman. who works for WP Engine, and he's American, very pro-privacy, and he tweeted, barely 1.5 weeks into GDPR, and it seems to have completely stopped being a source of any discussion in the tech circles I follow. And people replied to him, until the first lawsuits and judgments coming in. We're all waiting for a big case ruling to scare us into compliance. And this is actually just in a nutshell. It's that Americans can't get out of the mentality of a courtroom and a judge banging a gavel and a lawsuit and a crime, which is not how GDPR and the European privacy regime works at all. Take it to the other side of the Atlantic, and here's a quote from Elizabeth Denham, who is the UK's data protection regulator herself, and she said, under GDPR, we'll be able to use enforcement notices to require companies to delete algorithms or stop processing. That means stop doing the business. I think that's going to be as powerful, if not more powerful, than administrative fines. So what she's saying is she's not even talking about things like courtrooms and lawsuits. She's saying we can just shut your business down, simple as. And the two shall never meet, because when it comes to privacy, we don't even agree to disagree. So a couple of quotes that Europeans have said about GDPR and this approach. It's, why is the internet the Wild West? You know, a lack of progress may challenge the effectiveness of self-regulation in the area and may increase the pressure to legislate. And my favorite thing that Europeans say about the American approach to privacy is, we thank you for appearing to testify before our committee today. Whereas things the Americans say about our approach to privacy, jackbooted thugs. I've actually seen that. It could significantly interrupt transatlantic commerce and create unnecessary barriers to trade. And that's Donald Trump's chief of commerce. That's the Secretary of Commerce, who the official administration view of the European privacy regime is that it's a trade barrier. There should be no government involvement. But then this last quote comes along, and this was from the Zuck congressional hearings. I don't understand where we've reached a point where we, in the United States, are reliant on a foreign regulation to protect our data. The most remarkable thing to me, as I was watching Zuck getting grilled by Congress and eating all the popcorn, is that they all had to go through the political theater of thanking him for his American entrepreneurial spirit in starting this company, and then asking him, why didn't you follow X, Y, and Z, all of which came from European law? Because even Congress had nothing to fall back on but European privacy law. So the bottom line is, we all have a different understanding of what privacy is, how it works, and why it matters. It's not a good thing, it's not a bad thing, but you need to be aware that we all have that view. But who are we? We make open source software. We are people of enormous power and influence over privacy on the web. And we've never understood our differences, much less acknowledge them. And that lack of understanding about each other is what we bring to the table. And it has as much of an impact as our code. And what happens when those differences meet? We structure our work with different cultural approaches. We write our code with different legal approaches. We just assume, as I did for so many years, that everyone works and thinks like we do, like I do. I thought you all knew this stuff. Didn't you get this? And then we create the open web with no common standard for privacy. And we failed to do everything we could to protect the people and the data, and we don't learn from our mistakes. We have to do better. Because the actions we can take within our projects, however small, can protect the people in the data from those who would use that data to hurt them. And this is absolutely happening now. This isn't theory anymore. The first time I gave this talk, it was theory. There are children in camps. Some of you may lose your right to live in this country over the next 2 years. This is happening now. So we need to shift our thinking. We need to stop thinking of privacy as being that legal problem we got to run away from, and instead think of it as a cultural opportunity to embrace. That's bloody brilliant, Heather. How do we do that? Well, first thing I want to talk to you about in terms of switching this from theory to practice is the privacy by design framework. How many of you have heard of it? That is 100 times more than the first time I gave this talk. Thanks. So what is privacy by design? It's a non-regulatory development framework which was devised in Canada in the 1990s. And if you pull it up, it looks like it was written yesterday. It's an amazing piece of work. It's perfectly good. And it's always been there since the 90s for anyone to use, but GDPR incorporated privacy by design as a requirement. Going forward, you have to use this as part of your development methodology if you're not doing it already. So you're going to need to review your existing projects for best PBD practice and retrofit them if required, and make it just a part of everything you do to the point where you don't even think about it. And I'll give you a link at the end. I've put these slides online already, but I wrote a huge article at Smashing on the PBD framework, which you're welcome to read on your planes and trains home. So what is privacy by design about? There are 7 foundational principles. The first is that privacy must be proactive. Must be proactive, not reactive. That means anticipating privacy issues before they reach the user. And privacy has to be preventive, not remedial. Don't fix data breaches after they happen. We're going to have a case study in a minute. Privacy must be the default setting. The user should not have to take actions to secure their privacy, and consent for data sharing should not be assumed. So all these stupid, idiotic pop-ups that came in after May on every newspaper site, wanting you to opt out of 327 ad trackers to read a 3-paragraph story about a restaurant opening up, they're all supposed to be switched off by default. God forbid, nobody should have to buy privacy as a service, and that's a contentious thing with Whois. On the WordPress GDPR project, we got people who were apoplectic about the fact that we shipped the tools in core, not as a plugin. Plugin would mean a person would have to take conscious actions to know the tools existed, actively seek out the plugin and activate it. We stuck them in core, activated by default. Privacy must be built into design as, hey, a core function. It's not an add-on. It must be positive sum. There is no trade-off between privacy and security. There is no trade-off between privacy and service provision. If a site says you either accept everything we want to do under the sun with your data, or you can delete your account, that's not positive sum. Privacy by design requires end-to-end life cycle protection, and we'll get into this, but that means thinking about data minimization, your data retention periods, and your data deletion periods. I'd love to think that GDPR caused a massive purge of terabytes of data, which didn't need to be there in the first place, but a girl can dream. Privacy by design must be open. Everything you're doing with people's data must be out in the open, transparent, for the world to see, as are the privacy standards and laws you may be required to follow. And privacy must be user-centric. It's not about you, it's not about your company, it's about the user. So that means giving people granular privacy options, maximize privacy defaults, detailed privacy information notices, user-friendly options, clear notification of changes. All of this is kind of common sense, isn't it? And it's a shame that, what was it, almost 20 years people didn't use it, and now it has to be law. This isn't hard, this isn't rocket science, this is common sense, and it's called privacy by design. So how might you check your project for PBD? Well, the UK Data Protection Regulator, which is the ICO, producing really good information as fast as they humanly can when they're not dealing with things like people trying to hack our elections. So they've put out a PDF with really good, again, common sense questions like, we make data protection an essential component of the core functionality of our processing and services. We anticipate risks and privacy invasive events before they occur and take steps to prevent harm from individuals. Do you? Do you really think about these things? More questions. And this one's really important. When we use other systems, services, or products in our processing activities, we make sure that we only use those whose designers and manufacturers take data protection into account. That means your business partners. That means your APIs, that means the people you're working with. Do you really know what they're doing with the data you feed them? Because you're both liable now, and I'll get to that. So a key part of PBD is the privacy impact assessment. And this is probably the most ridiculous common sense idea out of all. It's a living document accessible to everyone within a project where you document what you're doing and why. Like what consent or legal basis you have for even doing this project, never mind collecting the data. And you document the risks to the data subject, to the organizations, to your technical and systems, and your risk mitigation. And again, why aren't you doing this anyway? This is what you do when you sit around a table before you've written a line of code and you talk about what data are we collecting, why do we need this, who are we sharing it with. There's 6 areas of PBD: data collection, retention, SAR, subject access rights, your legal compliance, your human technical security, risks. And this is one you always forget. Everyone forgets this because you're all developers and you all think in terms of code, but you don't think about people. Personnel, staff, and contributors, that's your first point of failure. So if you develop some sort of appalling privacy slurping app, which caused the Information Commissioner's office to send someone to knock on your door, and they say, show us your PIA for this app, and you say, and you kind of like tell them to go away and come back in an hour, and you Google something off a template, and you fill it in with what you think is going to be acceptable. It's not, because the first thing they're going to look at is the PIA section on personnel, staff, and contributors. They're going to ask, who had access to this data? What data protection training did they receive? Hold that thought. What security measures do those individuals work with? Did they have to log in? Did they have super admin rights? What data breach notification and alert procedures were in place? How come the only way you learned about the data breach of your own systems was someone complaining about it on Twitter? What procedures are in place for government requests? Which means, why weren't you expecting us? So that section on personnel, staff, and contributors, this is serious stuff. When a regulator is looking into why you failed, because you didn't follow PBD, they're going to want to know what data protection training the people working on the project received. Was that the European Privacy and Data Protection Framework? Was that any industry or sector regulations? You know, if you work something like financial sector, you have privacy obligations over and above GDPR. What about development frameworks and methodologies? What code libraries were you using? Who was checking them? Where's the documentation in your HR records of what people were required to know? Were people required to know this when you hired them? Did you give them any supplementary training? And you're going to say, and you're going to call your lawyer because your business is about to get shut down. So it's not knowing is no longer an excuse. And here's a case study of why not only is not knowing not an excuse, but doing it half-heartedly is worse than not at all. This was just a week ago. So did you see what happened with the Conservative Party conference app? Were you all watching that? I was avoiding a deadline, so I ended up tweet storming about this. It was great. I actually downloaded the app, which was just available to the public on the Google Play Store. Had a look at, and went to the privacy policy. I am that freak who goes straight to the privacy policy on everything. My daughter just loves me. Mom, can I play that game? No. I've not read the privacy. So first thing that jumps out at me is Australian legislation. It was an Australian company. And then they talk about European legislation. We comply with numerous legislative instruments in relation to European markets, in particular GDPR and the Charter of Fundamental Rights of the European Union. And this just tells me they hired a really bad lawyer to Google it, because nothing else in the privacy policy met what's required under GDPR in a privacy policy. And they talked about privacy laws means the Privacy Act, the European Convention on Human Rights, the Data Protection Act, 1998 UK, which tells me they didn't even get to the search and replace, because that's the old law. And then I had to look, permissions. These were all the things the app wanted to do to your phone. You could disable access for these permissions in settings. There's no settings. So this was not a PHP Scotland conference app. This was the Conservative Party conference. This was the cabinet. This was the Prime Minister. This was the heads of the armed forces. This was every journalist. You bet your backside some kid at a Moscow Starbucks had downloaded all of this. Some kid in a Moscow Starbucks could have logged in as the head of the armed forces and sent a message. So the head of the Conservative Party said, we've had a technical issue with our conference app. It's been resolved, and it's now functioning securely. To which me, avoiding a deadline, having a tweet storm, said, a bug is a technical. This is OPSEC, the national security. And you don't get to call it a technical issue when you're gathering a bunch of people in a room to talk about making Britain great again and regulating the stuffing out of the internet. So how did he follow up this? We're disappointed with our supplier. Personal data disaster is definitely all the responsibility of their Australian supplier and not, for instance, the person whose name would technically be on the contract. Whose fault was this? Both of them. They're both as bad as each other. The Conservative Party, as the client, had no excuse for not covering this due diligence in the contracting phase, never mind the project. The Australian app developer had no excuse for not knowing what, never mind what the law required, what basic, all you had to do was look up your MP's email address on Parliament's website, and that was their login. So if you do this, the client is going to publicly throw you under a bus. So don't think you're going to be able to blame them, because the buck will stop with you. So don't be that client, and don't be that developer. So in all the time I've been preaching this gospel, I get a lot of resistance. I don't just get resistance, I get trolling, I get actual abuse. Because privacy triggers people. Privacy triggers people because they think of it in terms of law. Europe telling us what to do. You're taking away my entitlement to do things with people's data. And I felt like I had to call that bluff. And that was to say, okay, fine, you've got a problem with Europe, you've got a problem with governments telling me what to do. That's your prerogative, but show me what you're doing to protect users' privacy. And I don't just mean like with your hand behind your back. Show me your methodology. Tell me what you're doing. Show me what standards you used. There's no standards, so I had to invent them. I had to come up with a way to measure the accountability of privacy work outside legal requirements. Answering the question of what is privacy about if it's a principle and not a law. So how was I going to come up with this? Well, being a geek, policy law geek, I looked at two kinds of privacy rules. One is hard law and regulation. That's things like GDPR. That's things like the judgments of the Court of Justice of the European Union when there have been privacy cases, things like COPPA and HIPAA, and the judgments of data protection regulators like ICO, the France's CNIL, the FTC, which is kind of sort of the privacy regulator in America, but it's not, but it kind of is for the purpose of this. And then there's soft law and regulation. Things like industry codes of conduct, ISO standards, international conventions, and the Privacy by Design framework. What people never realize is that hard laws build their foundations on soft laws. A bunch of bureaucrats didn't just go into a room and say, let's make something really difficult to piss people off and we'll call it GDPR. Everything that is in GDPR came from soft laws. It came from existing conventions and standards and frameworks. So let's start there. That's what I decided to do. I decided to use the same foundations that were used to create the European regime and come up with something that doesn't have the word law on it, but it's a methodology to use to describe common values. For the geeks who would want to see my work and my citations, I used OECD, the Council of Europe, ISO, the Asia Pacific Privacy Framework, and the FTC, or Fair Processing Principles. Some of you watching this video will know what it is. The rest of you can just go to sleep. And I reviewed all of them for the principles they addressed, which looks like a lot of random table cells. But what you realize when you're looking at this, they're all saying the same thing. They call it different things. But they're all saying the exact same things about the exact same areas. And there's actually only a handful of things that 30 years of privacy soft law have addressed. And from that, I've come up with the methodology to begin your evaluation of your privacy standards outside legal requirements. that's data minimization. Collect only the data you need and no more. Data integrity. Ensure that the data is true, authentic, and up to date. Purpose minimization. Use the data only for the purpose you collect it for and nothing else. Life cycle limitation. Don't use the data for other purposes, keep it longer than you need, or share it with others. Share it with others without reason. Human and technical security. Take adequate technical and human measures to protect the data from misuse and its subjects from harm. I call it Heather's Law. Heather's Law is when I am sitting in a cafe writing about data protection and privacy, and someone at the table next to me leaves their laptop logged in and open and gets up and goes outside to have a fag. I am going to steal a laptop one day as proof of concept. How many times have I seen those laptops have like corporate logos on the front, corporate logo stickers? You know, you can't prevent from data breaches. You can't prevent data breaches in code. You've got to start with people. Transparency and notice. Make public what data you hold, why you hold it, what you do with it, what rights people have over it. And those rights. User participation rights give people the right to access their data, correct mistakes, the right to ask you to stop using it. Accountability, enforcement, and redress. That just means fixing problems when things go wrong, putting it right when people are hurt, even if you have to put your hand in your pocket to do it, and face the music when something you've done has caused data misuse or a breach, whether or not it's caused hurt to people. Choice, control, and consent. Give people choices, give people options, give people rights over how you use their data at any time. Special categories of data. So take care with sensitive data, which could result in the people it is about being hurt. As we said at the beginning, religion, sexual preference, something like immigration status. For the love of God, immigration status should be treated as a protective category. Legal compliance. You should work cooperatively and productively with regulations, with regulators, within laws, and within supervisory bodies. Don't be, what's his name? Aaron Banks. So there, in a nutshell, is 11 basic universal privacy principles to begin developing your own methodology for your own work outside legal requirements, so that when those people come to me and say, you can't, I'm American, I'm Canadian, I'm South African, you can't tell me what to do, I can say, show me what you do along these lines, and then I'll believe you. I've put this on GitHub. It's a start. It's an idea. I've actually not looked at it in about a month. I don't know if anyone's put any pull requests. All these links are in the slides. Please use it, comment it, develop it. It's yours. It's a foundation. It's not been pulled out of thin air. It's been pulled out of 30 years of privacy standards, and do something with it. And there's a really, really important reason you should do it. Because as we just said, creating and following soft regulation principles for user privacy lessens the chances of hard regulation being imposed onto your project. I said we weren't going to talk about Brexit, but yeah, because they are going to begin regulating the British internet to the hilt. I firmly believe that 5 years out of the European Union, we will not recognize the web as it is now. We will look back on the most basic things we used to do with nostalgia. Regulate or be regulated, it's coming. And if you can prove you are doing something accountable, transparent, and responsible to a methodology, that is going to lessen the chances of them coming around and saying, you're not doing what we want, we're going to regulate this. So where to start with everything I've taught you, with the methodology, with the cultural differences, with privacy by design, with identifying within your projects and workplaces where you may have all misunderstood each other to the detriment of your projects. I would suggest you review your data capture, your sharing, your flows and retention. What are you collecting? From whom? Why? Who are you sharing it with? Where is it going? Where is it stored? How long are you keeping it? Why in God's name are you keeping it? Why? I have 12-year-old CD-ROMs from when I was a web designer from companies that don't exist anymore. Why? Because I can't find the shredder, is the honest answer, but I'll just put a plant under it and something. So conduct a privacy impact assessment, and I'll put a link up to an article which will give you a starter for that. Read up on GDPR, on privacy by design. I would suggest if you work with American clients, you start reading up on CCPA, which you're 2/3 of the way there already, if you were healthy with GDPR, and that open source methodology idea. And I want you to become privacy champions in your workplaces. Go back Monday and talk about this. Share these slides, share some of my talks, get the conversation going, and demonstrate leadership in privacy within your open source projects. Every time I pull up Slack, I am dealing with attitude. I mean absolute attitude from people for whom the concept of privacy is just regulations and laws and lawyers telling them what to do. And when they go low, I go high. I don't feed the trolls. I document the abuse. And I just appeal to the better angels of our nature in not taking it down to an abusive ad hominem. It's about protecting people. It's about protecting users. And it's about doing the right thing and live the values you're trying to convey. Don't stoop to their level. So what have you learned today? By now, I hope you know how to respect privacy as a positive cultural value rather than resenting it as some sort of negative legal obligation. I hope you know how to integrate best privacy practice, either by privacy by design, a healthier regard for the European legal framework, or taking a look at that methodology into your development workflow. I hope you're thinking about making a plan to review your existing work for some privacy improvements. And I hope maybe you're just a bit inspired to contribute to open source privacy work. And I'm very much cognizant of the fact that I am the woman standing between you and the bar. So I'll let you go there now. So I'd like to thank you for coming today. And if I come back in a year's time, I want you to show me what you've done. Thank you. I didn't fall over or die. This is really impressive.
Good job. Yeah, that was excellent. Obviously, we've got a couple of minutes, so do you want some Q&A time?
Are you saying I want under time?
Well, no.
Jesus, I am sick.
Are you okay with a couple of questions? I think there may well be one or two. So if anyone's got any questions... Oh, sorry.
Okay, so we'll start with you.
There's a screen in the way.
State of you right now.
Yeah.
I guess two questions wrapped in one. I'm down to know, you're American?
I grew up there, yeah.
Okay.
I've been here my whole adult life.
Where are you from?
DC.
Okay, it's 3 questions.
One left.
I don't know, I've been sweating just throughout this whole presentation because, I'm in the process of building an app and releasing an app. And I'm very aware of GDPR, and when it comes to sort of protecting other people's information, their data, making sure that it's accessible, there's no real simple way of implementing it. This is like a full thought-out process. Am I right in thinking that way? Instead of just some sort of copy and paste of some legal jargon. And
don't copy it. Well, I mean, the whole reason I did a talk at WordCamp London on privacy notices because, for example, the forward-facing privacy notices, there's no template. That's a response to the fact that privacy protection for 23 years was copy and pasting legal jargon. It's not about that anymore. What I would recommend is just the data protection GDPR page has a lot of resources for you to use. Best thing you can do is just make it a part of your workflow, that you think about these problems, you think about these potential hazards before you've done any work. Better to do that work before you start than after the proverbial horse has bolted and the data's been breached. Well, I was just when I was going to bed last night, I was reading about some sort of data broker that holds literally billions of entries on people, had a major breach. And it's the sort of thing you never gave your consent for it to be used. Apollo, yeah. There's only so many things I can deal with on one day. I know it's hard and I know it's a bit arduous, but I take it you're from the States?
Yes.
So, as I said, regulation is coming. So you're gonna be a year ahead of everyone you work with if you take this homework back, jump on it, Who knows, in a year from now, you could be the one giving the talks, teaching people how we integrated privacy practice into our workflow ahead of the regulation. I'd recommend on a practical level to read up on CCPA, because if you have any service users in California, you're going to follow into it. But GDPR is always going to be slightly more rigid than CCPA. So if you're only interested in legal compliance, go with CCPA. If you're interested in user protection, go with GDPR. And that's the best advice I can give to you. The regulation is coming. We've all got to make that jump. Okay. The person next to, aye.
Okay, a very quick question I have in regard to GDPR. One of the concerns I have with GDPR is simply that the ICO, from my understanding, is not really well resourced enough to actually properly enforce GDPR.
Oh, you should have seen them last year. I mean, they've had to double staff. They've had to, I know they got permission to raise wages past civil service rates. At one point, they were losing 60% of their staff every year to the private sector. And that was before they had Cambridge Analytica and Facebook and electoral interference drop into their lap. What is going to help them is when the fines start rolling in from Facebook. Now, under the old Data Protection Act, the max fine was £500,000, because again, that was set in 1998. Did I see the other day that for the breach last week, Facebook could be facing a £1 billion fine? That's going to fund a lot of data protection officers, and it's also going to fund things like taxes in schools and the things we used to have before tech companies ran everything through Irish tax shelters. So bring it, is what I'm saying. So that's not to say that you should assume that the ICO isn't going to come knocking. They have an office over by that bar. They have a Scottish office over by, why do I only think of Edinburgh in terms of bars? Yeah, they're growing and they're being paid better. And what you can do, if you're wanting to be really proactive, is they will come to your workplace and do an audit. Friendly, not threatening. They're not looking to, they will just say, okay, here's what could do better. I want to get a jump on that. Oh, is everyone registered with the ICO? Because the first thing they're going to say when they come around is, where's your registration as a data processor? Okay, that's your homework for tonight.
So as you say, like more legislation is coming like in the US, and the thing that I'm starting to wonder a bit, or like what scares me a bit about this is that, you know, running a two-person company essentially, offering a global service, this is not limited to the EU and the US, but there's other countries following up with this. And I think it's starting to become a little, like thinking of this ahead, I feel like in 10 years, this is becoming a little overwhelming. Like how am I going to be able to comply with this on a worldwide level? And so a bit like, what do you think about the international aspect of this, and also with the what you were saying about how the US or like the American view on this and the European one is very different? What do you think about the future of things like Privacy Shield? And is that even going to be possible in the long run?
Privacy Shield, the United States is insisting it's the best thing in the world. And the oversight board hasn't even met in a year and a half because it's not quorate. I mean, that's just how ridiculous that is. As I said, we are all going to have a lot of different privacy laws to comply with. So that's why one of the ideas behind the methodology is a common baseline. You're not going to be expected to comply with, I don't know, Malaysian privacy law for the 10 people who downloaded your app in Malaysia. But you might expect to demonstrate best practice for the 200,000 who downloaded it in the next country. So if you have some sort of baseline standard, which at the moment GDPR is the most comprehensive one, that will show you in good stead. It's not going to be perfect. I don't think it's going to be some sort of lawyer's dream of, you know, you serve 10 people in Tasmania and therefore you must follow this to the left. Work to a baseline, work to a best practice, work to the letter of whatever country you're registered in, your business, your project is registered in, and that will show you in good stead as well.
I think that's us on time
Is
now.
it?
So
Oh, really? Oh.
is that?
Okay.